Non-students and non-faculty, welcome. Happy Constitution Day. My name is Rigel Oliveri. I am just going to be the moderator for this panel on the Affordable Care Act and the Supreme Court case that upheld it. We have a lot of material to cover, so I'll be very brief in introducing our panelists. Stan Hudson, on the left here, is the Associate Director of the NU Center for Health Policy. He manages a diverse range of research and service projects focused on things such as Medicaid data, healthcare, the healthcare workforce, health insurance, access and affordability, and health disparities. Next is Thom Lambert. He is the Judge C.A. Leedy Professor of Law. His scholarship focuses on regulatory theory and business law, so he's going to be talking to us about the economic aspects of the Affordable Care Act. To my right is Phil Peters, Professor Phil Peters. He teaches healthcare law and policy, and he's also an expert in health law. He's the Ruth L. Hulston Professor of Law. And coming in right now is, is Professor Josh Hawley. Professor Hawley is, he's a former clerk to Chief Justice Roberts of the U.S. Supreme Court, who was the author of the majority opinion that upheld most of the Affordable Care Act. And he also had a constitutional law practice in Washington, D.C. before he joined us on the faculty. So welcome, everyone. Thank you. And I will begin by asking Stan Hudson to just talk a little bit about the reasons why the Affordable Care Act came into being and how the legislation attempts to address those reasons.
Okay, well, I'll be very brief and try to stick more in broad generalities and getting into all the specifics of the 2,000 pages that the law is. But, you know, basically what had happened to American healthcare is, you know, we have three main issues in healthcare that we look at: access to healthcare, healthcare quality, and healthcare costs. And in our country, we have quite a few people who have difficulty accessing healthcare. Partially because they don't have insurance, and so one of the main goals of this law was to expand that access to health coverage through health insurance, and so there were numerous attempts to do that. One that has already gone into place that you may be aware of if you're under 26 was that they allowed children under the age of 26 to stay on their parents' plans, and that's really so far been the first kind of step that's already taken place. That came into being last year, and since that has come into being, there have been about 3.1 million people added within that age group. So it was the only significant increase in any uninsured group last year. So there has been a little bit of an impact on that. There were other ways that they were going to access health insurance coverage. So they were going to create insurance exchanges, which would then allow folks to go out and be able to shop around for health insurance. You know, a lot of our health insurance right now is employer-based. And so when you get a job, you get options based on what your employer selects for you, and you don't have truly a lot of choice. You may have choice between, say, an HMO plan or a preferred provider organization plan or those sorts of things, but you don't really get to choose between Blue Cross Blue Shield or some of the others. And so that exchange, when they come online, and the states can form their own, or we'll have a federal exchange that will come online. Once that comes into place, then you'll have a kind of a one-stop shop where you can compare some insurance plans and at least kind of look at your options and see what's out there. And as part of that too, there are going to be some subsidies and things that will be allowed for folks who can't quite afford to buy into that health insurance, so that they can buy into those exchanges. And then the last step that they wanted to do to really expand health insurance coverage was to force states to expand their medical eligibility roles for Medicare, or for Medicaid, I'm sorry. And Medicaid, you know, I don't know if you're familiar with that program, but it's a government-funded program where they set the requirements, but each state is allowed to form their own plan as long as they meet those requirements. And right now, their Medicaid program, it targets mainly children, pregnant women, and things like that. In our state, we have a Medicaid program. We do not provide Medicaid coverage for any adults who do not have children. So if you're a single, or if you're married and you don't have kids and you're making very limited amount of income, you still wouldn't qualify no matter how much you're making. And part of the Fed plan was to start to expand those eligibilities, so that would have been expanded up to 133% of poverty level. So that would hopefully, give some more options for some of those folks who couldn't afford it. The other things that the bill tried to do that were, I think, some of the larger issues with our health system is impacting healthcare quality and healthcare cost. Right now, when you look at the statistics, our healthcare costs are higher than any other developed nation that is out there. And when you start to look at the quality returns on that investment, it is pretty meager. And so we spend on average about 16 to 17% of our gross domestic product on healthcare right now. So that's quite a bit. That's almost a fifth of all of our money going to healthcare. Whereas in other nations such as the UK, they're only spending about 6 to 7% of their GDP on healthcare. And when you look at the quality returns, what you see is that in those nations, they're going to the hospital more, they're spending less time in the hospital, they're having much better outcomes, their life expectancy is better. And so when you start to look at this sort of a quality return on investment, America's not getting a very good deal. And so that's one of the reasons I think too that for the first time, we've been trying to pass these sort of health reforms for quite a while that would expand access to some sort of form of universal coverage, maybe not a government option, but some sort of universal coverage. And this is the first time in the last 60 years that they were able to really push something through. And I think part of that is these economic pressures that companies are now feeling as they're competing globally with these other countries, and they're not having to pay as high a healthcare costs as we are. And so I think those are just the main issues, just in a nutshell. And I invite any of the other panelists to add to that.
Just a second. Do you guys do your microphones work? Do they come on?
They're just for recording purposes.
We could have them turned on in the room, I bet, though, if
They're
you
not
can't hear me.
Okay.
Yeah, we can all just try to speak
talk
loudly
loud.
too. Did anyone have anything to add to what to Stan's sort of brief summary of what the law entails? Well, then I'd like to turn over to Josh to talk about the legal challenges to the law and the outcome of the Supreme Court's opinion on the case.
I'd just like to say it's very unfair to me to ask me to summarize this court's opinion in anything less than half an hour. But I'm going to do it very quickly. So the states challenged the Affordable Care Act on two principal grounds. The first one is they challenged the individual mandate and its accompanying penalty as an unconstitutional use of the Commerce Clause authority. And then they also challenged the Medicaid expansion. I'm going to set aside the challenge to the Medicaid expansion and focus just on the Commerce Clause challenge to the individual mandate. That's what the bulk of the court's opinion was devoted to. And the state's challenge went something like this. They said, never before in our history has Congress been permitted to order individuals to purchase something if they're not already participating in a market of some sort. So they said, the Commerce Clause doesn't allow Congress to do that. It allows Congress to regulate individual participation in interstate commerce or business participation in interstate commerce, but it does not allow Congress to compel you to enter commerce. That is, to go into a market in which you are not already participating. And that is really where the challenge, the nub of the Commerce Clause conflict was presented. That's where it lay. So the states made this argument. The government argued that, in fact, Congress had really what amounts to near plenary authority under the Commerce Clause if Congress's regulation would have substantial economic effects, basically, or to put it a different way, if you as individuals, we as individuals are taking actions that have significant effects in an interstate market, whether or not we're directly participating in that market, then the government argued Congress can regulate us, can regulate individual decisions, including can tell individuals, the government said, that they must purchase certain products, they must behave in the market in a certain way. So the court, in an opinion written by Chief Justice Roberts, or I should say more accurately, Chief Justice Roberts concluded, first in his opinion, that the Commerce Clause did not extend that far, and then in the second part of his opinion, he concluded, nevertheless, the individual mandate was still valid, it was still constitutional, because it could be construed as a tax, and therefore constitutionally valid under the separate taxing power, rather than as an exercise of the Commerce Clause power. Now, this is an exceptionally complicated case because Chief Justice Roberts did not, in fact, get a majority for any part of his opinion except the second part, as to the taxing power. So 4 other justices agreed with him that the mandate could be construed as a tax, and that gave him a 5-4 majority. As to the part about the Commerce Clause not permitting Congress to order people to buy products, 4 other justices did, in fact, 4 different justices did, in fact, agree with him on that part, but they didn't join his opinion. So we actually had an opinion by the Chief Justice in which he speaks only for himself as to the Commerce Clause part. 4 justices dissent. 4 other justices write a different opinion on the clause. So we have no majority opinion as to the Commerce Clause. And then in the second portion where he said, but despite the Commerce Clause problems, it can be characterized as a tax, there we have a 5-4 majority with 4 dissenters. So let me talk just briefly about the Commerce Clause portion in the Chief Justice's opinion. And he basically agreed with the state's arguments. He said that the key precedents that the government cites, including the all-important case of Wickard versus Filburn, which is a case about a farmer who grew a certain amount of wheat, and he was permitted by law, this was during the Depression, he was permitted by law only to grow a certain amount of wheat, and he grew more than he was allotted, and the government fined him. The Chief Justice said, even that case, which is a very expansive interpretation of the Commerce Clause, even that case does not permit the government to order people to go out and buy things. Wickard was already producing the wheat. He was already engaged in some sort of economic activity. But the government can't tell you, if you're not involved in the insurance market at all, if you haven't purchased insurance, you're not doing anything, they can't tell you to go out and buy it. So the Chief Justice, writing for only himself, said that the Commerce Clause doesn't allow you to do that. And then he said, that leaves us, of course, with a constitutional problem. And then he applied this thing called the canon of constitutional avoidance, which everybody who's taken legislation will recognize. It's a venerable canon. The courts invoke it fairly frequently. And Chief Justice Roberts said, because under the Commerce Clause, Congress has no power to do that, we have a significant constitutional problem. And the canon of constitutional avoidance tells us that if there is another plausible interpretation of the statute that will avoid the constitutional problem, then we, the courts, ought to pick that interpretation. And so he said, we could characterize this thing as a tax. Is it the best interpretation of it? No. He said it's not. It's not the best interpretation. Is it a plausible interpretation? The Chief Justice concluded, yes, that it was plausible to recharacterize the individual mandate as a tax. So basically, as the Chief Justice had it, in this second part of the opinion, he was joined by Kagan, Breyer, Ginsburg, and Sotomayor for a majority of 5. He said that the mandate should be read in order to avoid constitutional problems. It should be read as optional. So the law basically says you may either buy insurance or pay a fee, pay a tax. It's an option. It's not a command. So you haven't broken the law if you pay the tax. And so therefore it's an exercise, this penalty, he said, is best characterized or can be characterized in order to avoid the constitutional problem as an exercise of the government's taxing power under the Constitution. And again, he got 5 total votes, including his own, for that position. So the question going forward is, what happens to that Commerce Clause portion? And if you want to know, we can talk maybe more about this in the question and answer portion, but if you want my opinion as to what the Chief Justice was doing, why he ruled in the way he did, my guess is, and it's only a guess, but my guess is he thought that he could write an opinion that would significantly constrict Congress's authority to regulate under the Commerce Clause, would roll it back, but would also, in the same opinion, allow this law to stand and therefore avoid significant, potentially disastrous political fallout. So he thought he was doing both things. But the question is, because he could not get 5 votes for his opinion on the Commerce Clause, does his Commerce Clause holding, does it actually bind in future cases? Or is it what courts call dicta? So it's in his opinion, but it doesn't actually control in future cases. And so that, I think there'll be a lot of debate about that in future cases, beginning in the lower courts, probably beginning very soon, as to whether or not the Chief Justice's opinion as to the Commerce Clause, as to the limits on the Commerce Clause, is actually good law, whether it actually is law at all or is it just dicta. And then the second consequence, the question mark going forward, is to the scope of the tax power. The Chief Justice's opinion had the somewhat, I think, ironic effect of dramatically increasing we're dramatically broadening the permissible scope of regulation under the taxing power, because the Chief Justice suggested that the taxing power and the Commerce Clause power are completely divorced. So Congress could do stuff under the taxing power that it could absolutely not do under the Commerce Clause power. Which raises the question, well, in the future, will Congress just be able to recharacterize any regulation that is otherwise problematic? Will it just recharacterize it as a tax and be able to get away with it? And even though the Chief Justice said in his opinion, Congress' ability to use its taxing power to influence conduct is not without limits, that's a quote, he provided no examples of those limits. So in closing a door, did he open a window? The Chief Justice opened a window. The dissenters accused him, Scalia, Thomas, Alito, and Kennedy accused him of doing just that. He says no, time will tell. So here's my best effort.
Phil, I was wondering if you wanted to just follow up a little bit with what why upholding the mandate was important, what that means for the legislation going forward now.
Tom, you're going to do short, right? So everybody's been timing. That gives me about 30 minutes. Exactly. I have to stand. I apologize, but I just have to stand. This is 30 years of teaching, and I can't say the Affordable Care Act, before the Affordable Care Act takes its most significant provisions into effect, tens of thousands of people die right now every year because they can't get heart bypasses or organ transplantation or expensive pharmaceuticals that would otherwise save their lives. Tens of thousands. This is on par with other difficult diseases like breast cancer. So we have that situation. Tens of thousands of others can't wait eagerly every month to turn 65 so that hip that keeps them in a wheelchair can be replaced. So those are the needs that the Act was meant to fix, and it's taken a step in that direction. But it's done so in a very, very complicated way. It's complicated because it tries to do two things at once. It tries to bring more people onto the lifeboat, but to do that in preserving as much as possible the private market for health insurance and healthcare services. And accomplishing them both together proves to be very difficult. It would be much simpler constitutionally, you need no mandate, and administratively in terms of 2,000 pages of law, if you simply expanded Medicare to cover everything. But that's not what Americans want. Americans want more market role, and so the statute was designed in a way that was meant to be maximizing the private market role in the hopes of acquiring bipartisan support. In fact, the plan itself is drafted on a plan that was created by a conservative think tank from the Clinton era as a market-based alternative to the Clinton plan. And in fact, it's the plan that was adopted by a Republican governor in Massachusetts, again, because it preserves a significant amount of market role. But it's tough to do both. Well, why is that? That's because the healthcare market, the market for health insurance, not for health services, but insurance is a little bit different than the markets for, say, television or wheat. And that's because health insurers have a rational reason not to want to insure people who are sick or people who are at risk of being sick. Those are bad sales. And in fact, they have a rational incentive to get rid of you if they find out that you're sick or likely to be sick. At the same time, they have a rational reason not to sell insurance below cost just because a low-income worker can't afford the cost. That would make no sense. And yet, a low-income, a minimum wage worker makes about, in total, the same amount as one family policy for health insurance. Right? You take 100% of their income, 15 grand plus, to buy a health insurance package for their family. So we have these two barriers that have to be overcome if we want the market to work. We have to figure out what we do with high-risk people and what we do with the working poor with low income. And so the Act puts in place what two pieces that will take effect in 2014 that will start to address each of those two market barriers. For working poor, you have expansion of Medicare and Medicaid in states that decide to adopt it. That's one of the implications of the Supreme Court decisions. It gives states the option of whether to buy into the expansion. The second way they help low-income people is by giving subsidies to working poor who make between 133% and 400% of the poverty. So that's one strategy to deal with the working. What about the high-risk individuals? This is where the Supreme Court's decision ends up being very, very important. For high-risk individuals, the goal everybody likes, it's sort of unanimous in America, like 80% of the public says, let's get rid of pre-existing condition clauses. Let's not have a person's access to health insurance depend on whether they have to draw the short straw on health, on cancer, blood pressure, whatever. But it turns out that for that to work, you have to take your medicine, so to speak. You've got to take the good with the bad. For that to work, you need mandates. And that's what people, a lot of people don't like about the bill. Well, why do you need mandates? Because private insurers rightly told Congress, you can't make us get rid of a pre-existing condition because insurance doesn't work well if somebody can go, who has a fire in their house, can call up an insurance company and say, you know that fire insurance policy? I'll take it. It doesn't work that way. You can't have just the people who need the coverage in the market. You need everybody in the market, and so they share it. They subsidize the person who draws the short straw, and that works with health insurance too. And so the insurers convinced the legislators to do this. Obama campaigned against a mandate, but he gave in. He said, they convinced him, if you want to keep the market and have universal health care, you need a mandate. 7 states had tried implementing an exclusion of pre-existing condition clauses. We'll take the dessert, but we aren't going to eat our meal and our dinner. And all 7 states had to repeal those laws because it didn't work. You had adverse selection, rates went up. 1 state successfully avoided that, Massachusetts, which adopted a plan that had an individual mandate to go along with the elimination of pre-existing condition clauses. So that's why the Supreme Court's decision was so crucial. Health policy advocates around the country are really holding their breath on this. All kinds of Plan Bs and Plan Cs were being written, but none of them were really very confidence-inducing as to what would happen if you didn't get a mandate to work. Now, it's still hypothetical whether it was crucial or not, but there was a lot of worry that it was. And so the Supreme Court's decision to uphold the mandate really laid the groundwork for putting the mandate into effect rather than requiring a significant Plan B legislation, which probably would not pass today. So that's where we are. Subsidies and pre-existing condition clauses combined with mandates will take effect January 1st of 2014. There will be a ton of glitches, for sure. The statute this complicated. We already know several of them, and there are debates about whether the agencies will work them out, or whether the Congress will need to fix them, or whether they'll just be glitches that don't get fixed. But to some extent, that's inescapable when you try to do the 2 goals that I mentioned Congress had. If you want to preserve the market and use it to distribute the good and bring more people onto the lifeboat, then you've got to put together a product that looks a little bit like this, and that's what Congress did.
Now Thom can explain for us some of the economic ramifications for what Congress did with this, and he's got a presentation.
Let's see, how do you do this? Selection. Is that it?
Yes.
All right. Students who've taken my contracts class know that I have a somewhat unhealthy fascination with felines. I was writing a piece on the Affordable Care Act this summer, and I kept accidentally typing Affordable Care Cat. And someone sent me this, and of course you know that this is actually the case. The Affordable Care Cat is a tax. This is the proper name of my talk here, how the Roberts Court's healthcare decision dooms the ACA to failure. I think that there's a problem with the Affordable Care Act that has been exacerbated to some degree by the reasoning of NFIB versus Avelius. That's the name of the Affordable Care Act decision. Phil has explained a lot of the stuff I needed to explain, so that's great. The ACA has 2 sort of price control provisions that are actually quite popular. It's, you know, a lot of people don't like the statute, but people tend to like these provisions of the statute, the dessert, as Phil calls them. One is guaranteed issue. An insurance company has to insure you regardless of pre-existing conditions. The other is community rating, which basically says that the premiums are not going to be based on your sickness or your susceptibility to sickness. Instead, they can be based solely on your location, your smoker status, and to some degree your age, and that's actually quite regulated in the statute. So these things people like. You can get insurance, and you can get it at a rate that doesn't reflect your susceptibility to illness. Here's the problem that's created by this sort of price regulation, and Phil has already mentioned this, so I can say it really quickly. If you are a young, healthy person, insurance is really expensive. It's about $4,000 for a 35-year-old for a year. It's about $11,000 for a family of 4 headed by a 35-year-old. That's a lot of money. You don't really need health insurance until you have to make a big medical expenditure. If we have guaranteed issue, which says when you go to get the insurance, the company has to sell it to you, and we have community ratings saying that they have to sell it to you regardless of your pre-existing conditions, then you have an incentive, if you're young and healthy, not to buy insurance, to wait until you sort of need healthcare, need to make a really big healthcare expenditure, then call up the company and buy the insurance. Right, so, WWYHPD, what would young healthy people do? They would tend to drop out of the market, drop their health insurance until they actually need healthcare, at which point they go and buy it at a really low rate. Right. Now, what happens when young healthy people drop coverage is that insurance premiums go up for everybody else. Insurance premiums, as you know, are based on the sort of expected underlying medical costs of the covered population. So when you have the healthy people drop out, the cost for everybody else goes way up. Right? So this would be a very bad thing. Economists refer to this as adverse selection. All right, so how the ACA deals with adverse selection? Well, we're familiar with one of these things. We've talked about it quite a bit. The individual mandate. Individuals have to carry minimum health insurance or pay some penalty that's tied to income, to their income level. The penalty, see, in 2014, the penalty starts at $95 per year for an individual, and it goes up. In 2016, the maximum penalty would be about $2,085 for a family in 2016. In addition to the individual mandate, the Act imposes employer mandates, basically says if an employee with a firm with greater than 50 employees, if any employee from such a firm buys insurance on a subsidized exchange, which they would do if they're subject to an individual mandate and the employer doesn't provide health insurance, then the employer will be charged $2,000 a year. Okay, so employers are expected to provide to their employees. Individuals are expected to purchase insurance if their employer doesn't provide it. Otherwise, everybody has to pay a penalty. Right, here's the problem. The penalties in the Affordable Care Act are really small. You know, suppose a parking meter costs $1 and the ticket is only 75 cents. If the cost of compliance is actually greater than the penalty cost, then who's going to comply, right? Okay, so Chief Justice Roberts, in his opinion, pointed out that the penalties in the Affordable Care Act are quite small. This is taken from the opinion. Individuals making $35,000 a year are expected to pay $60 a month, in which they don't have health insurance. If you make $100,000 a year, you'd owe about $200 a month. But the price of a qualifying insurance policy is projected to be $400 a month. So the individual making $35,000 a year says, do I pay the $60 penalty, and then when I get sick, I call up and I get insurance at a price that's not reflecting my sickness, or do I pay the $400 a month when I don't need health care? Well, a lot of people are going to have a tendency not to pay until they really need the coverage. All right, so the Affordable Care Act has responded to this small penalties matter by providing subsidies for people to go out and buy insurance. The statute provides that subsidies are available on state exchanges for individuals and families that earn up to 400% of the federal poverty level. So for a family of 4, that comes out to about $92,000 in 2014. It'll be more than that, obviously in the future. So that's a lot of people. Most people can get subsidies to buy health insurance. So the key question here is the amount of the penalty greater than the out-of-pocket insurance expenditure? So that's the policy cost minus the subsidy amount. If the amount of the penalty is not greater than the out-of-pocket insurance expenditure, then it might make more sense to go ahead and just pay the penalty, not buy insurance until you need it. Then we have the adverse selection problem. Let me say one other thing. Once adverse selection gets started, it's really hard to undo it because as healthy young people drop out of the pool, prices for insurance go higher, which means more healthy young people drop out of the pool, driving prices higher, and it's a really pernicious cycle here. Okay, I crunched some numbers here and to show you how the subsidies work. What we have here in the left column is family income, maximum percentage of income you're supposed to spend on insurance pursuant to the statute. And then the third column tells you basically how much a family of 4 would spend for insurance per year. The maximum penalty in 2016, maximum penalty for anybody that's going to get a subsidy would be $2,085, so about $2,000. If you look here, you see that at about $45,000 of income, it actually makes more sense for you to pay the $2,000 penalty than to buy the insurance. And obviously, as income gets higher, the incentive to drop out of the market it gets greater and greater. Only at the very low levels is there an incentive to actually go ahead and purchase insurance. Now, this is actually the true facts are more extreme than this, because this is looking at 2016 numbers when the penalty gets as big as that will ever get. For the first 2 years, the penalty is significantly lower than 2016. In 2014, it's $95 for an individual. So what we're going to have in 2014 and 2015 is a lot of people with a very strong incentive, healthy people, to drop out of the market, which should have the effect of causing insurance premiums to rise, causing more people to drop out of the market. Adverse selection gets started, and it's pretty tough to stop. Now, here's my main point. An effect of this decision, I think, is to lock in these low penalties. Chief Justice Roberts, in his portion of his opinion explaining why the penalty for non-carriage, failure to carry insurance is a tax, emphasized 3 aspects here. Shared responsibility payment may for constitutional purposes be considered a tax, not a penalty. 3 things. First, for most Americans, the amount due will be far less than the price of insurance, and by statute it can never be more. It may often be a reasonable financial decision to make payment rather than purchase insurance, unlike the prohibitory financial punishment in another case. The other 2 things that he emphasized are that the penalty is imposed regardless of scienter, regardless of whether you intended to violate the law or not. And then third, the penalty is collected by the IRS, so it looks like a tax. But those 3 things were the things that constitutionally turned this penalty into a tax. If Congress were to drastically increase the size of the penalties to combat adverse selection, then as a constitutional matter, they may no longer be a penalty, which calls into question the entire statute. So, in sum, when we combine guaranteed issue plus community rating, plus constitutionally constrained small penalties, my concern is that we're going to end up with widespread adverse selection that will drive insurance premiums through the roof and undermine the Affordable Care Act. Sorry to be a downer, but
Well, and I thought we could finish up by having Stan talk about some of the issues that he sees sort of coming down the pike now with implementation of the Affordable Care Act as it was upheld by the Supreme Court, sort of going forward from a state level. What do we expect to see, and what are going to be some of the challenges?
Well, I think you all have set me up very good, because the one thing that we really haven't talked about is that employer mandate, and the fact that what the Supreme Court did rule unconstitutional was that the feds couldn't coerce states into expanding Medicaid by withholding their current Medicaid funding. And because of that, then that made that option for states to expand Medicaid an optional case. There are lots of states, such as Missouri, whose legislators are saying, you know, even if we wanted to expand Medicaid, we don't have the budget to do it, so we're not going to do it. And what could happen then is in a state like Missouri, you could have large employers or small employers look at those penalties and decide that those penalties are cheaper for us to pay than to cover our employees. And so they would drop everyone and leave them to the individual markets or to fight for getting coverage on those exchanges. And if you don't expand, the way the law was supposed to work was, if that happened then, those folks who didn't quite make, you know, only made $15,000, $20,000 a year, they wouldn't be able to afford coverage even on the exchange with those subsidies. So the goal would be then they would be picked up by Medicaid. And so if Medicaid doesn't expand, those folks wouldn't get picked up. You'd actually have the exact opposite of what the law was supposed to do, which was to expand health insurance, and this could actually limit health insurance, because now you have companies dropping folks. You don't have any other options, so now you're kind of back in the same boat. So it's gonna be very interesting to see how this gets implemented as it comes down, and to really see how much they're able to play with those penalties, because you know, a lot of economists that I talked to said you're going to have to raise those penalties to get people in those pools. Insurance pooling only works if you can get everybody in those pools. And if you've got the healthy, I mean, that's what's happening now, except insurance companies are just more active about it. If I can use pre-existing conditions to deny you, I can keep my pool as healthy as possible and spend as little as I can, and so I get to keep that as corporate profits. And so I think that's one issue. We have a unique issue here in Missouri too as well, because our legislators there is an initiative that's coming to ballot in November where the people will get to decide on whether or not we have any sort of exchange. And if we vote yes on that legislation, it would actually make it illegal for anyone to work on forming an exchange in the state, and that entity could be sued. And so this is an interesting case that's coming through, an interesting initiative to see how Missouri reacts to that, because if we decide that we don't want an exchange here, the feds are going to impose one on us. I mean, that's the ACA's law. If states do not set up their own exchange, then the feds will create one, and everybody within that state will be eligible to enter that exchange. So it's kind of interesting that, you know, there's resistance because we don't want to participate in a federal program. We don't want a federal program put on us, but if we don't participate and if we don't create our own exchange, then that may be exactly what happens. And so those are kind of two of the, I think, really pressing issues that we're facing. And a lot of states have just kind of put this on hold. You know, they've decided we're not going to act on this at all until first the Supreme Court ruled. Now the Supreme Court has ruled. Other states saying, well, now we're going to wait and see how the election goes. And if it's not like here in Missouri, we actually have that initiative, then it's more based on the general election of the president and the Congress.
Anyone else on the panel want to add anything to that?
Well, one point I think is worth knowing factually, of the 30, there are 50 million uninsured roughly. 32 million was the estimate of the number of people who would be added by the act if fully implemented. Half of them, 16 million, would have been through Medicaid. So to the extent that the court's decision to allow states to opt out is taken up by states, that'll reduce the uptake, the amount of new insurers. It will also reduce the cost to the Treasury, so it will have that benefit, but it would change the estimated numbers of people who end up getting extra insurance.
Yeah, in Missouri, it was estimated that if we expanded our Medicaid to what they were requiring in ACA, that it would add about a little over 300,000 people to the rolls. But it was also estimated that if we didn't, you know, if we didn't expand Medicaid, that out of that 300,000, about 240,000 of them would not be able to afford it under the subsidies and tax credits that are offered.
So it sounds as if, and I'm not an expert, but I've just been listening to the panel, it sounds as if by creating the legal regime that the court did by classifying the individual mandate as a tax, and by saying that to make it a tax, that means it's got to stay relatively low. I imagine also the low numbers might have had something to do with sort of making it politically palatable to the general public. You're not going to get taxed really heavily, you're just going to get a small penalty. But that creates these sort of perverse economic incentives to basically accomplish the opposite of what the law was intended to, unless the amounts go up. And without the Medicaid expansion, that might end up, as you said, Stan, leaving people in the exact position that the law was trying to avoid. So these are some very thorny issues. And I now would open it up, unless anyone else on the panel has anything more to say, I'd like to open it up for questions from the audience here. Yes?
Collecting Professor Lambert's table.
Oh, sure. Oops, sorry.
So if median family income in a state like Missouri is, I think, $44,000, the disincentive for people who are at the lower end of the economic scale is not nearly as significant as you're describing. And it's also, it seems to me it's plausible that the individuals who are most disadvantaged who have the greatest adverse selection are also likely to be people whose employers, because of the income they earn, most likely to be in employment where health insurance is part of the benefit. Would you comment on that?
Sure, absolutely. That's great. Thank you. You're right that my table is kind of skewed more toward upper income people, but the reason for that is because once you get below family income of $30,000 or so, you're actually in the Medicaid expansion world. Yeah. Because the statute calls for Medicaid to be expanded to reach 133% of federal poverty.
I guess the point I was trying to make was that the people who are 45,000 or something and lower are going to have an incentive to participate, to buy insurance, and that at least some significant portion of those people, I don't know where the cutoff point is, whether it's 50,000 or 75,000 or what family income, are much more likely to be in employer-provided health care that's not going to be taken away from them. Right.
So two responses to that. One is, remember that on my little table here, this is when the penalties get to their highest point. So for the first 2 years, the incentives are the penalty for failure to carry insurance is really small. So we can see at the outset some pretty low income people that are still incentivized not to purchase health insurance. So that'd be one point. But the other point, I'm glad you brought up the employer thing. I created more slides than I had time to discuss. But let me mention this. So currently, and most people know this, I think, just from the discussion, employer-provided health insurance benefits are tax-free. If you buy your health insurance yourself, you're taxed on it. Okay, so that means that the government is essentially subsidizing employer-provided health insurance, and if you want to calculate the amount of the subsidy, it would be the value of the policy times your marginal income tax rate. For most middle-income people, that's going to be a 15% rate. Plus the payroll tax, if you add that all together, it ends up being about 22.65%. Okay, so if your employer provides health insurance to you, and you're a sort of middle-income person, you're getting effectively a federal subsidy of about $3,400, an implicit tax subsidy on a $15,000 family policy. Now, the way the ACA is structured, it allows you to get subsidized insurance on a state exchange if your employer doesn't provide qualifying insurance. The subsidy on the state exchange is tremendous, significantly greater than the implicit tax subsidy that you get from having health insurance provided by your employer. So it is actually in employees' interest, lower income employees' interest, to have their employer not provide health insurance so that they can take advantage of the greater subsidy on the exchange, and rather than just get the small tax subsidy that you would get from employer-provided health insurance. And so I think that we're going to see a lot of employers dropping health coverage, not just because they want to protect their bottom line, but because it's actually in their employees' interest for them to do so, so that the employees can take advantage of the greater subsidy on the exchange. And once that happens, then that sort of undermines your assumption that everybody's going to be, or lots of these lower income people are going to be getting their insurance from their employer. I
wasn't making that assumption. I was making the assumption that their interest at the very low end, if they weren't getting insurance coverage from the employer, to pay the penalty. But this is, I hadn't done this math, so this is a little, it'd be much more interesting at about $65,000 or $80,000 to think about that.
There is, by the way, if you want to do math on this, a great thing on the internet, if you go to the Kaiser Family Foundation Premium Support Subsidy. It's a great thing the Kaiser Family Foundation put together. You can enter all these numbers and figure out, if I make this much money, how much do I have to pay for insurance and all that sort of stuff.
Can I just say one thing legally about the subsidies, which turned out to be so important? As the act is written, if the state does not set up an insurance exchange that Stan and Tom have been talking about, as the act is written, the subsidies for individuals are not available. If the state does not set up the exchange, the subsidies for individuals are not available. The federal government will set up the exchange, but the subsidies are not available, which would be a huge crisis. Now, the HHS has tried to paper over this, what was clearly a drafting error, by issuing a regulation saying that, well, henceforth, subsidies will be available. But I promise you this will be thoroughly litigated.
This is the statutory provision that Josh is referring to, where the statute limits the subsidies to a state-established exchange.
Yeah, I would add one other thing to your incentives is that under this you're starting to see some incredibly new and innovative incentives come out from businesses. Especially I've already seen with the stipulation around allowing people to stay on their parents' plan until 26. Some companies have figured out that it's cheaper for them to get their younger employees to stay on their parents' plan, and they're incentivizing it and providing $400 a month if that employee decides to just stay on his parents' plan instead of buying into the full health benefit package. And so the way that these incentive structures are currently being done in companies, I think is going to change a lot, and there'll be a lot of new creative offerings that you may have as an employee.
Just a question in the back, yes.
Yeah, hi. Okay, so first I want to just explain that I'm really not trying to make a point. The point here is purely intellectual curiosity. So I've noticed in my studies that ever since the ink has dried in the Constitution, that constitutional challenges on tax laws really have gone generally unsuccessful. So as Professor Hawley said earlier, Justice Roberts leaves the door open to this idea of a limitation on the tax power. So for the lawyers on the panel, in the future, what is the viability of arguing against any kind of tax, against taxing power? I mean, where would you devote your man hours or woman hours at your firm if you were arguing to that argument? Would you make that at all? Would you make that argument at all?
I think there will be litigation, Blake, about this, absolutely, because there hasn't been a significant amount of litigation or a significant number of court cases about the scope of the taxing power since the 1930s, because at about that time, the court, by opening the door for the commerce power, made further use of the taxing power, not necessary, really. Congress could do almost anything it wanted under the commerce power. So part of the sort of odd thing about this decision is that the Chief Justice is forced to interpret these decisions from the 20s and 30s that nobody has looked at in a long time, and the dissenters actually don't have much to say about them. So I think you will see a lot of fighting about just what the scope of the taxation power is. And is the taxation power, is it effectively plenary? As you could, if you read the Chief Justice's opinion for all it's worth, you might think that. Now he says it's not the case, but you might think that even in the examples that he gives, for instance. So I think you will see a pretty fair amount of litigation.
Time for one more question. Yes, sir.
Do we think all this confusion hastens the day we'll have single-payer insurance?
No. No, I don't think so. I think, in some sense, if the act had been struck down at its core, a generation from now, you might have seen an attempt to get one more time to get single payer. I think it likely now that supporters of universal access will try to work with this. So of course, it's repealed, and it's a reset button. And then if it's not repealed, then these problems end up bringing it down. There are a whole host of problems in trying to pull this off. If they bring it down, then you'd also have a reset button. But I think if it seems to limp along, doing enough so that the people who supported it are willing to keep working to try to fix it, then you're unlikely to see it move towards single payer. States may be free to try it. Vermont seems to be on the road to trying it, but not the federal.
I think we probably have time for one more question. Andrew in the back? Yeah.
Well, you made it sound like, first of all, that is it just politically unpopular for them to raise the penalties on the insurance so that it's more economical feasible to buy insurance? And if that's true, if the federal government for some reason can't raise those penalties, then isn't there going to be a strong incentive for states who have apparently, under Massachusetts, the power to provide individual mandates? Won't states just start mandating people to buy health care when they see outrageous premiums to drive costs down?
So, two questions. One, is it just politically unpopular, or is that the constraint?
Why can't the federal government?
The argument I'm making, and this is, I'm parsing Justice Roberts' reasoning. But one of the things he emphasizes, one of the three things he says about this penalty that makes it a tax is that it's small relative to the cost of compliance. How constitutionally necessary that is, or how much smaller than the cost of compliance it has to be, that's an open question. But my point is there is a constitutional dimension here. And so I'm making more than just a political point. Although I agree with you that it will be politically hard, I think, to raise the penalties. One of the reasons they were so low when the statute was being debated is because we didn't want to look like we were penalizing people so much. As far as the states go, yeah, maybe the states could do that, but would be really leery of expecting the states to step in and do that. As of a couple of weeks ago, 36 states had not done anything to set up an exchange. I mean, the states are fighting this tooth and nail.
But that's now before the act is, before the act is implemented. If what you say happens, insurance premiums skyrocket, and the federal government is taking no action to raise penalties or repeal the act, then, aren't the states going to be forced to do something? Otherwise, no one in their state will have insurance.
Good point.
That might actually be a sort of scary but interesting note to leave things on. We're just about out of time. Please join me in thanking our panelists for this very